which is the two full versions of the Act in English and Welsh. Pepper and Todd. The Welsh language version of the document at tab 27 of the authorities, so the Office of the Welsh Council, in a different language version. And I believe also the plenary debates, although those just need to be identified first of all.
That was my Lord's point.
In terms of numbers, my Lord Justice Boss raised with me a question about numbers about secondary schools with and without sixth forms. The figures from the Welsh Government give a total of 182 secondary schools, of which 126 have sixth forms. Now, I understand those are figures now rather than figures in 2013, so obviously subject to that slightly. And 23 middle schools, of which 12 have sixth forms. Well, I understand that to be referring to a school with a wide age range, so it might be where it has a sixth form, it might be 3 to 19.
I thought middle school was 13 onwards.
Well,
we have some middle schools.
That's...
We're still waiting.
Yeah.
We might go on.
My Lord Justice Lewis asked me about Pepper and Hart this morning, and my submission is that the exclusionary rule in Pepper and Hart, to the extent that it is still applicable and it has been somewhat relaxed since 1993, is still properly applicable to proceedings of the Welsh Assembly as it was in 2011, 2012, or indeed the Senate now, on the basis that the reasons for the exclusionary rule are not simply of reasons that are reflected in Article 9 of the Bill of Rights and the difficulty of questioning proceedings of Parliament. It may be helpful if I just take you to Pepper and Hart briefly, if it has reached the Richards.
Anyway,
if one goes to Pepper and Hart, and the ultimate exclusionary rule was set out in the judgment of Lord Brown-Wilkins at 40. The reasoning that leads up to that rule has various strands. And one of those strands is the nature of oral debate in a democratic assembly, which is reflected in various places. So one sees it 620 D to E in Lord Oliver's speech, where he refers to the hope of unearthing some perhaps incautious expression of opinion. One sees it at 632 This is now the speech of Lord Brown-Wilkins. There, at the bottom of the page, at H, Lord Brown-Wilkins quotes Lord Cynon Taf and Davies and Pontypridd. material, the parliamentary material, is an unreliable guide to the meaning of what is enacted. It promotes confusion, not clarity. The cut and thrust of debate and the pressures of executive responsibility, the essential features of open and responsible government, not always conducive to a clear and unbiased explanation of the meaning of technical language. So that's 632 each. And 634, Lord Brown Wilkinson essentially puts the same point in his own words, where he says it may be unwise to attach importance to ministerial explanations, this is between A and B, which are made to satisfy the political requirements of persuasion and debate, often under pressure of time and business. Now, I say that those points are equally applicable to any democratic democracy. They do explain why there is a need for caution when taking into account the content of all the debates that may not similarly exist when one is talking about a carefully prepared pre-legislative document such as white paper and so that's pepper and salt. I was also going to give your lordship some dates. The amended grant, the Welsh language grant, was given permission by the Justice Chancellor at the beginning of April 2020. The detailed grant, and I apologise for having initially got it in the wrong order, the detailed grant for the 20th 2020. Ms. Lyles' statement was the 4th of May, and Ms. Howell's second witness statement in response was the 12th of May. So, my Lord, I was just coming on to ground 4. And I was about to address what I said was the counterfactual premise that the court did find against the council on breach of paragraph 1.4 of the code as well as 1.9. And I say that there would be two insuperable problems with such a finding. The first being that it had not been pleaded, and I fully take on board and accept that in our detailed grounds we mention paragraph 1.4 as the provision of the code that we say would be applicable. But just because the other party has mentioned it does not thereby become part of the case. And once we had got the amended basis for running the case as explained in Miss Lyles' witness statement and as explained in my learned friend's skeleton, was the significance of 1.4 of the code more or less entirely disappeared. One can see perhaps it's useful to turn up the council skeleton below at core bundle page 183. Say 183. Yes. And paragraph 73. Dealt with in a single paragraph, in a very summary fashion. And I dealt with it already in any greater detail than that, because I have no reason to do so.
Well, I mean, why would you have been saying to the court that you complied with that obligation if there wasn't an allegation which hadn't?
Exactly. Exactly. The other related point, of course, on breach of the code, breach of 1.4 of the code, that the primary facts necessary to deal with this and the evidential material is really not covered at all in the judgment, or not in any way that could be viewed as halfway sufficient. Because for the reasons I've given, in fact, the court was concentrating upon an allegation of breach of 1.9. So we say there would have been an obvious unfairness insofar as the judge did find against us on paragraph 1.4 of the code, because it was a case of which we had not had notice and which we did not properly address as a result. So that's the first point. But the second point we say is that any suggestion of breach of 1.4 of the code is unarguable on the facts. So we say it is wrong, as well as vitiated by procedural irregularity. And 1.4 is at page 24 of the supplementary bundle. It would be worth just turning it up to have it to hand. The essence of it is a mandatory requirement to ensure that there are sufficient schools providing primary and secondary education for their area, having regard to number and character, and projected demand for schools within a particular language category. And we say, unarguably, that requirement was met in respect of the proposal to close Pontypridd and open a new Welsh medium primary on the Hill and Kelly site. And there's several factual points to make on the evidence. The first is that the catchment area for the proposed new Eolicalene school was designed so as to include the whole of the current catchment area for YGG Pontypridd. There are several references to that. I'll just give you one of them from the documentation, and that's in the consultation document, page 134 of the supplementary bundle. Catchment area of the new school. The catchment area of the new school will comprise that of the existing YGG Pontypridd, together with that of the current Welsh medium stream of Hill and Kelly Primary School. Secondly, the proposed Welsh medium school at Hill and Kelly, the new school, would have significantly expanded capacity for Welsh medium education in comparison with that available at a combination of YGG Pontypridd and the current Welsh medium stream of the current primary on the Eolicalene site, which is a dual language primary. And one sees that also from the consultation document, and it's supplementary bundle, page 131. And if one looks at that, you've got pupil projections and capacity for the schools addressed. So you'll see that YGG Pontypridd has a school capacity of 267. The pupil projections go slightly down, and it's estimated that by 2023 it will have 15% surplus cases. Hayley Killeen has 120 capacity in its Welsh medium stream, with quite a substantial surplus by January 2023. Then below that, you've got proposed new school site and building. And that says the proposed capacity of the new school will be 480 plus 60 nursery places. The expected cost will be 10.7 million. So in other words, one has there a planned capacity of 480 by comparison to a current capacity of 387. So it's adding 93 places, this plan. And the council deems that capacity, with the additional 93 places, to be future-proofed, which is also something that 1.4 of the code requires to be future-proofed. Well, it means that it is projected to be able to accommodate future demand, projected demand over the next few years. And one sees that from page 220, which is the Welsh language impact assessment. Underneath access to Welsh medium education. 220. 220 is a supplementary one. The capacity of the new school building will be 480 pupils plus 60 nursery places, which represents an increase over the existing YGD Pontypridd Norton combined with the Welsh stream of Killeen, almost 100 places. It is considered that this capacity will be sufficient to cater for current and forecasted pupil demand, and it will also allow for growth in the Welsh medium sector. So that's the second point on the facts. The third point on the facts is that the new school at Killeen was considered by the council to be reasonably accessible for all pupils from YGD Pontypridd Norton. And indeed that was a point that the council considered in a great deal of detail because it was a feature of various objections to the proposal. And I will take you to a brief selection of the documents addressing this. Page 212 of the supplementary bundle is the community impact assessment concerning this proposal. And the important paragraph for present purposes is the penultimate paragraph on page 212. That makes first of all the point that the catchment area will encompass that of the existing two schools. The relocation of YGD Pontypridd Norton to the Killeen site will mean that all pupils resident within the school's current catchment area will qualify for and receive free home-to-school transport as they will reside more than 1.5 miles from the new school. No child resident in Killeen part of the catchment will qualify as number will reside more than 1 mile from the school. It's not considered that distance to school will be a barrier to any child who wishes to participate in the pre- and after-school provision of the offered in the new school. And then importantly, it is estimated that the maximum length of time any child will have to take to travel to the new school will be 20 minutes. Now, that is important, we say, because that matches up with the requirement for consideration of travel in paragraph 1.4 of the code, which says you have to particularly look where you think that a primary school pupil will have to travel more than 45 minutes. So, very much inside that outer perimeter.
Just to be pedantic, before we leave that paragraph, third line down, all pupils resident within this school's current catchment area, that must be a reference to Ponsile.
Yes, it is. Yes.
It's not clear in the English, and that's what it means.
Yeah, yeah.
Here again,
Then the 221, which is the Welsh language impact assessment, there's a passage about travel, which starts towards the bottom of the page. Nearly 70% of the pupils, it's just below the second whole bunch. Nearly 70% of the pupils currently attend YGG, Pontypridd and Norton use home to school transport, and the location of the new school in Bwrdeistref would enable 100% of those pupils currently within the catchment of YGG, Pontypridd and Norton to qualify for free home to school transport. Therefore, for the vast majority of pupils attending YGG, Pontypridd and Norton, access to school clubs and extracurricular activities will remain unchanged. It is common for learners accessing Welsh medium education to be transported to and from school, and access to before and after school activities can be a challenge in those cases. And over the page...
But can I just understand that?
Yes.
So at the moment, 70% of pupils at YGG are further than the statutory requirement for walking and so get transport.
My Lord, I'm so sorry, just to say, not the statutory requirement, but the 1.5 miles.
The 1.5
more generous than...
More generous than that, yeah. So the 70% are outside the 1.5 and will go to Pontypridd on. And after it's gone to the new school on the Hurricane site, everyone, 100% will be more than 1.5, but they'll get school transport. And it'll be school transport for the after schools, will it?
Yes, that's... Yes.
That's what I understood.
Exactly. Sorry, yes.
35% now, 20% now more than 1.5. 100% after will be more than 1.5. But there'll be free transport for school and the school up school things.
Then over the page, one has a section about school bus routes. School bus route distances of the new routes proposed will be shorter than the current school bus routes travelled. The transport unit has calculated the routes, and the average overall distance travelled for those pupils who already use school transport will be shortened by just over 1 mile a day. Actual distances are recorded in the table below. One can see it's a slight opposite. AM mileage goes down by 2.9 and PM mileage goes up by 1.8. I think that's a feature of the fact that
a big one-way system, isn't it?
Yes, exactly. Yes. Then those pupils who currently do not travel to YGG, Pontypridd and Norton by bus, as they live within the 1.5 mile in catchment walking distance, will qualify for free home to school transport to the new school. The furthest that these pupils will have to travel to school will be 4.5 miles each way to the new school. And at page 223, second paragraph, it must be stressed that YGG, Pontypridd and Norton is a well-established, successful school, and whereas this proposal involves its closure, its provision will in fact be relocated to a brand new building to be constructed less than 2 miles away from its current site. We say, well, that's important, because we're not, Kelly is not sort of 10 miles away, it's 2 miles away. So, if one then has a look at that sort of primary material and compares it to paragraph 1.4 of the code, supplementary bundle, page 25. I say it is absolutely plain that 1.4 of the code has been met. The Council has considered, first bullet point, whether alternative accommodation of at least equivalent quality for existing and projected pupil numbers. It is considered, the second bullet point, whether it's sufficient to meet existing and projected demand for schools of the same language category. And by reference to the italicised text on 25, it has carried out a Welsh language impact assessment. And further, it has also considered, next bullet point, the nature of journeys to alternative provision and resulting journey times for pupils, including SEN pupils, in particular whether primary school pupils will have one-way journeys in excess of 45 minutes, or secondary school pupils one-way journeys of over an hour. So all those matters we say are absolutely plainly considered. And if a clear allegation has been made, breach of 1.4 of the code, which it was not, I would have answered it by reference to all those matters. Those do not appear as part of the judgment because they were not part of the argument below. So that's ground 4. And finally, I'll move to round 5. And that is also a belt and braces ground, because it only comes into play, we say, if the court is against the council on ground 3 and finds that paragraph 1.9 of the code requires the council to have regard to the impact of primary education proposals upon Welsh medium provision. In the 14 to 19.
Also an answer to that as well, because you're worried about the effect on Welsh medium secondary education. If children stop going to Welsh language primary schools, then it seems to me they go to an English language one for secondary school rather than staying within the Welsh medium stream.
Yes.
And what you just showed, the answer to ground 5 on your case, isn't it?
I wanted to take you to some further documentation, my lord, but yes. And what happens here is that the court took Miss Howell's witness evidence that the council does recognise that primary school take-up has an influence upon secondary school take-up, which of course I think is a sort of very obvious point, and said, well, I do not consider that that is actually what the council did take into account. In other words, Ms Howell's evidence was wrong. And the starting point, we say, is as a matter of principle how evidence should be treated where it's not been tested under cross-examination. And we rely upon what was said in a case called S against Airedale National Health Service Trust, which is tab 15 of your authority file. I'll just give you a page. Page 501. This is one of the first instance decisions that was dealt with as Munjas in the House of Lords. It's not for the Munjas guidance that we need to go to, but rather for what's said in paragraphs 18 and 19. Under the evidence on page 25, Mr. Justice Stanley Burns, well, there are issues of primary fact. Then it is a convention of our litigation that at trial, in general, the evidence of a witness is accepted unless he's cross-examined and is thus given the opportunity to rebut allegations made against him. There may be an exception where there's undisputed objective evidence inconsistent with that of the witness that cannot sensibly be explained away. In other words, the witness's testimony is manifestly wrong. But that is not the present case. The general rule applies as much in judicial review proceedings as in other litigation education, although in judicial review proceedings it's relatively unusual for there to be a conflict of testimony, and even more unusual for there to be cross-examination of witnesses. And I say that principle applies to Miss Howell's evidence for the council in this case, no less than it applied to Dr. Kehoe in Hess against Airedale. And thus, the court was entitled to say that it rejected Miss Howell's evidence that the council had taken into account the effect of reorganising primary provision upon secondary education, only if contemporaneous documentation showed it to be incorrect. And I say that contemporaneous documentation didn't show that it was incorrect, it showed that it was correct. Now, Miss Howell's second witness statement made the point, and I'll pick it up at page 343 of the supplemental bundle. Paragraph 28. The Council, of course, recognises that changes to Welsh medium primary education have an impact on take-up of Welsh medium secondary education. This is reflected in the Welsh Education Strategic Plan, where it notes that by increasing the number of pupils in Welsh medium primary education and retaining those pupils throughout the key stages, this will enable the Council to meet its objectives of having more students aged 14 to 19 in study subjects through the medium of Welsh. As I also explained in my first witness statement, the Council had regard to the Welsh Education Strategic Plan in drawing up the proposals, and the proposal for the reorganisation of Welsh primary education was a means of realising the objectives set out in the Welsh Education Strategic Plan. Now, the Welsh Education Strategic Plan is a document which you have starting at page 34 of the supplementary bundle. And that sets out a vision and aim for Welsh medium education. It is all about trying to meet the Council's bit of the Welsh Government's target of having 1 million Welsh speakers in Wales by 2050. And in order to do that, there are various outcomes set out in the plan. You've got outcome 1, for instance, which is internal pagination, page 6. More 7-year-old children being taught through the medium of Welsh, so there's primary education outcome and how that's going to be met. Then outcome 2 is also a primary education outcome, and one can see that, well, it's a sort of primary, it's the transfer from primary to secondary school. It's page 17, internal page 17. Then outcomes 3 and 4 are about secondary level education. So outcome 3, more students aged 14 to 16 studying for qualification through the medium of Welsh. This is now, sorry, page 53 of the supplementary bundle, page 20, internal pagination of the document. And outcome 4, which fairly closely tracks the language of the relevant bit of the code at 1.9, there's more students aged 14 to 19 in study subjects through the medium of Welsh in schools, colleges and work-based learning. Then at the bottom of that page, there's a heading, Objectives, Outcomes 3 and 4, and then a paragraph that says, much of the objectives for meeting targets within these outcomes, so outcomes 3 and 4, are dependent on meeting objectives in outcomes 1 and 2 to increase the number of pupils in Welsh medium education and retain these pupils in these ages. These are also closely objectives in outcome 5. So it's specifically recognised in the Welsh Education Strategic Plan that what you do at primary stage, the availability of Welsh medium primary education, is not only capable but obviously affects what happens at secondary stage. And this is something that Ms Howell has said the Council took into account when it drew up its proposal. And the fact that the Welsh Education Strategic Plan fed into the Council's proposal here is also reflected in a report to Cabinet of the 9th of April 2019 on planning for Welsh medium education places. And that's page 145 of the supplemental report. So, section 4 on page 146 is about the availability of Welsh medium provision in the county borough. And it mentions the council's statutory responsibility to ensure a sufficient supply of suitable school places, 4.1. Then 4.2, the council is also required to produce the Welsh Education Statutory Plan, West, which covers the period 2017 to 2020 and was approved by Cabinet in 2016. The West sets out the council's vision and objectives, etc. And then at 4.2, you've got the council's plans for Welsh medium primary schools. And at bullet point 3, the council is currently consulting on building a new Welsh medium school for the pupils of Pontypridd and Norton and Hill E. Kenny to provide an additional 90 spaces. So I say on the face of the documents, there's plenty of evidence that the council made the Pontypridd and Norton proposal as part of its strategy for fulfilling the goals in the Welsh Education Strategic Plan and increasing the number of Welsh speakers in its area. And the Welsh Education Strategic Plan itself shows the council had well in mind, as might be thought obvious, that fulfilling its goals for Welsh medium secondary education and thus increasing Welsh speakers generally was tied into increasing numbers of pupils in Welsh medium primary education. So that's subject to checking behind what I need to take you to on the document. My Lord, my Lady, can I just turn to how the High Court addressed this in its judgment? And the relevant reasoning starts at paragraph 116, Call Bundle, page 73. So the first thing that's said there, paragraph 116, is the court said, well, the council relies on the fact that it decided not to reorganise Welsh medium secondary education as a defence to this ground, having considered a number of ways this could potentially be done. There are difficulties with that line of defence because it ignores that there's an obvious link, and one which is essentially accepted, between proposal 4 and the impact that will have on Welsh medium secondary education. Now I say that's illogical point to make, because the court's criticism goes back to Miss Howell's first witness statement, supplementary bundle, page 295. Paragraph 105. Actually, I should start by asking you to look at paragraph 103. And perhaps if you could read paragraphs 103 to 105. The reason Ms. Howell said this is because paragraph 1.9 of the Code is about proposals to reorganise secondary schools or to add or remove sixth forms. So unsurprisingly, Ms. Howell was here answering the only case that the Council considered could logically be made on paragraph 1.9 of the Code. And at this point, when she was making her first witness statement, the claimant had not yet made clear by Miss Lyle's evidence that its case on paragraph 1.9 of the Code wasn't that the Council hadn't considered matters it should have considered in making its secondary education proposals, but was rather based upon the Pontypridd Norton primary school proposal. So, in my submission, the court's criticism of the Council's evidence at paragraph 116 really amounts to criticism of Ms. Howell and the Council for properly understanding the Code. Then at 117, the court says that its finding is borne out by the entries in the consultation document, which only set out very cursorily the advantages and disadvantages of alternative options, and don't spell out the advantages and disadvantages in terms of the impact upon Welsh medium secondary education. And all I say in response to that is that paragraph 1.9 of the Code is not about the content of the Council's consultation documents. It's about what the Council has or hasn't taken into account when drawing up and deciding upon proposals.
You draw up the proposals and then you consult upon them, don't you?
Yes.
But then you decide to implement them. So ultimately it's what they decided on when they decided to implement them. But you can't say the consultation comes first because you can't publish the proposals, but you've got to consult on them.
No, I'm not trying to, no. I mean, the consultation is, I'm not trying to say that the consultation comes first, but what I am saying is that you cannot deduce from the content of the consultation document that goes to the public that everything that the Council took into account is spelt out in the consultation document.
Sorry.
Then at 119, the court said that the supposedly inadequate content of the Council's Welsh language impact assessment showed that it had failed to consider how changes to Welsh medium primary education would or might impact upon Welsh medium secondary education. But I say the Welsh language impact assessment in fact showed that the Council did consider how changes to Welsh medium primary education would or might impact upon Welsh medium secondary education. I might take you to page 223, the supplemental bundle.
Sorry, which page?
223. You see, the third paragraph is all about meeting the Welsh in Education strategic plan of having 1 million people in Wales able to speak Welsh by 2050. And it is absolutely adherent to that, and you've just seen the bits of the Welsh in Education strategic plan dealing with it, that this is all about retaining pupils through key stages. Now, actually what the court was really getting at in my submission is apparent from paragraph 120 of the judgment. Because what paragraph 120 is doing is, it seems to be the court saying, well, the Welsh language impact assessment should have addressed matters on the premise that pupils would be lost to Welsh medium education because they'd be placed into English medium education when Pontypridd Norton was closed. And on the basis of witness evidence given by the claimants. The claimants have advanced evidence from a number of people who stated their language preference for the education of their children will, as a result of these proposals, have to change and they will be able to receive education in Welsh. Now, the trouble with that approach is that it assumes a premise which the defendant did not accept. It assumes that the new site for Welsh medium education at Sirol was going to be unreasonably difficult for many parents from Pontypridd to access. And the council did not accept that. And I've taken you to the Welsh language impact assessment and the other documents that explain in some detail why the council thought that was wrong. In other words, the new site is less than 2 miles away from Pontypridd Norton. The council thought maximum journey would be 20 minutes, and overall the proposed new school bus routes would be about 1 mile shorter. So, having reached those conclusions, the council was not, in my submission, required to deal with matters on the basis that pupils would be lost to Welsh medium education, when its own view was that more people would be able to access Welsh medium education, including all the people currently at Pontypridd Norton.
So, more pupils currently at Sirol Norton, and also any ones coming along, because the ones who are there might be able to stick with it now, it's 4 miles well after covering it. But the fear is that the ones that are coming along shortly, that you say, it's not just existing, you say, as I understand it, it covered everybody, born and yet to be born.
Yes. So in my submission, the court was not entitled to reject the power of evidence on what the council took into account, because her evidence was not inconsistent with contemporaneous documentation, but consistent. And in my submission, none of the court's reasons for reaching the contrary conclusion was logical. So, on that basis, I say that ground 5 should, in my respective submission, be allowed. My Lord, my Lady, can I just check behind me? Unless there's anything else. Thank you very much.
Yes, Mr. Williams.
So I can start by saying a little as to what we say the aim of the 2013 was. And you see the sense in looking at the documentation surrounding that chronologically, that's why I think that it took only one objection in relation to virtually any proposal, and the matter could not be determined finally by the local education authority. The issue
that you said that the previous regime had one objection to force it into the Welsh Ministers.
yes, there were other matters, closure of schools with virtually no people attending, and there was of course the question of sixth form education, which I think have always been matter for the Welsh Ministers. But when one looks at the background of the act, it is clearly the issue about objections which was of most concern. And virtually everything that was said in the white paper and indeed the explanatory memorandum in our needs to be looked at in that light. It's also true to say that the number of boroughs was excessive. Talking about hundreds, and even dozens, but there clearly was perceived to be.
It isn't very relevant whether you think it's excessive or not excessive. If the Welsh Minister thinks it's excessive, that's the end of it.
Well, yes, but what I'm making is the numbers were not huge. I'm going to make a submission that if there were a case which technically needs to be referred, and on the facts of the case, the Welsh Minister feel that a local could feel that itself it would be open to be delegate. That power does exist.
I mean, how does that matter? I mean, we're concerned with what the legislation said, not with what could have happened in different circumstances.
Well, of course, in our primary submission in the legislation, it is that it clearly describes a set of events which, in respect to proposals 2, 3, did require a referral to the Welsh Minister. We say that's laid on the face of the legislation. But a lot was made this morning about the purpose of the Act and it was set out in these various assembly papers. And in our submission, when one looks at them in detail, the real problem that was being dealt with by this had nothing to do with sixth form education at all. It was all to do with the problem with referrals because of unwithdrawn objections, even a single objection. So when one also should take on looking at the white paper that had 10 in the authorities bundle, turning page 11, and the section 3, school organisation, when you're also taken to the answer to the question, why are we proposing a change? It says we consider that because responsibility for planning and providing school places rests with the local authorities rather than with the Welsh Government, decisions should be part of the local be made at the local level rather than by ministers. Yes, but it's in that context.
No, I've got to try and follow you. You're in page 10.
In tab 10, 661.
161.
Yes. And indeed, 2 paragraphs down from what I've just read out, this paragraph in the heading, we believe that the current legislation, which allows a single objector without a direct interest in the schools, cause a referral to Welsh Ministers is inappropriate. So that's the principal problem that the legislation seeking to address.
Can you really say that? Because it begins by an inclusive objection at the top. Why are we in the vast majority of cases, these should be done at local level, then it goes on to say, we also consider that if it takes too long and delays, that's a separate thing. Otherwise, it wouldn't say we also. And then it goes on to give a third thing. We believe that a single objection then was referred to be appropriate. It then goes on to the problem this and then it says finally at the end. So these aren't different, these are different things, aren't they? There are different reasons, a combination of reasons.
Yes, the second paragraph deals with the procedure, which even upon referral was and will have been streamlined. Of course, that's not the difference between the parties, so whether the procedure should be streamlined, whether it should kick in at all. And it's absolutely right when one looks at the legislation. There's now a time limit for what local authorities must, when they must refer the proposals that are to go to the Welsh Ministers, and what documentation they must send them, including, for instance, the objections that have been received, if any, and the answers to those objections in the form of their objection reports. But what this does not emphasise in any way, and that was the impression I was trying to give this morning, was that the reduction in cases is because of the need to get rid of referrals in respect of sixth form education reorganisation. And therefore, if we turn on to internal page 14, and the question, the little e, we intend that Welsh Ministers will determine all proposals concerning the removal of sixth forms or the addition of sixth forms, including the closure of sixth form only schools. There is, in our submission, no need whatsoever to doubt the judge's interpretation of that. It was correct. It was what we submitted to them. If it concerns all proposals concerning the removal of sixth forms, that should include the closure of sixth form only schools. It clearly covered the closure of a school which contained a sixth form. And the reason for that, and this is the other principal reason behind the rationale for the way the Act makes a distinction between education for those over 16 and compulsory education for those under. It is the question of funding. The explanation is the Welsh Ministers have statutory responsibilities in relation to post-16 education and the provision of sufficient places, and are directly responsible for funding post-16 education provision. In light of these responsibilities, we consider it appropriate that the Welsh Ministers exercise a strong element of control over post-16 proposals. And that means all of them.
But as part of it, that's the wording, we intend that the Welsh Ministers will determine all proposals concerning the removal of sixth forms or the addition of sixth forms. So if you're removing it or adding it, something else is still there. And then it says the closure of sixth form only schools. It's concerning a closure of a school at the end, and the taking away or the putting in something into another school, isn't it?
Well, if one removes an entire school into sixth form, one removes sixth form.
Then you should say concerning the closure of schools which have a sixth form.
Well, not necessarily. It is obviously the fact that there is a sixth form which is being removed, which should be of additional concern to the Welsh Ministers. But if a school contains a sixth form and it is the whole school is closed, then the sixth form is removed. And the rationale, the explanation wouldn't make any sense if removal of sixth forms were to be read in the way your Lordship has suggested, because the responsibility for funding does not depend on whether the sixth form is attached to years 7 to 11. I sort of promised by a nod this morning that I would make sure that I covered off the Welsh versions of this guidance. In this respect, we don't really see any difference. Tab 11 is the Welsh version, tab 11, yes, is the Welsh version of this white paper. And the passage I've just taken your Lordship to is internal page 16. I'm not sure how best to deal with this. Your Lordship's content if I simply translate what I see on the page.
Well, if you say there's no difference,
You don't need to make good the submission that there's no difference.
No.
If there is no difference, we'll accept there's no difference. If you're saying there is a difference, then we will have to engage in the Welsh.
very slight difference now in the choice of words in B, which talks about penderfynu ar bob cynnig yn ymwneud â chael gwared. Now, in translation of that may be removed, but it would certainly cover getting rid of, disposing of completely, regardless of whether or not the sixth form is attached to other years. So that rather supports my submission.
But it could be neither, couldn't it?
Well, it clearly covers. It's surprised you're suggesting that there was a restriction in how removal should be understood. Then, in our submission, that does indicate that it is the wider that has been included.
The problems with that again then, when we're going to dig beyond Cymru.
Bydd yn penderfynu ar bob cynnig.
Well, stop there, so you're doing all proposals, all cynnig.
Yes.
And I had a high power.
Which are to do with, I suppose, which involve chael, as mutation after R, chael gwared ar dosbarthiadau chwech, to get rid of sixth forms. Neu'n ychwanegu dosbarthiadau chwech, or sixth forms, that's not.
That seems to be the same. That's what I'm saying. It's up to God really as to whether we move to something that's left, or remove something. Or,
well, it clearly covers the two instances.
yes.
Which is it does. Then the next bit after the comma means included, doesn't it?
Yes, gangynnwys is included closing schools which are, which do not have within them, which only have within them sixth forms.
It seems to me we've got the same problem unless when I grew up, it's to say, it almost begs the question, are you removing it? In the sense you're taking away the whole thing, which includes the sixth form, or whether you're removing the sixth form, and by sort of object, whatever the word is for sort of object, leaving the rest of the school in place. It's a down to it, is it?
Yeah, well, remove covers both those ideas.
Please understand it. It's capable of covering both. It doesn't demand one only.
No, well,
yes, it's capable. So it doesn't answer it. It's capable of covering both. Capable of covering either of them.
But given that the submission they made against me was that this makes it quite clear that the Council's interpretation must be right. In my submission, one looks at the context and then this language. Okay, that's not so.
Well, you say removal is ambiguous in English, and you say it's the same in Welsh because the Noira Walred, is capable of being either of the two situations you've got.
Yeah.
Yeah. The stuck is still ambiguous then. Okay.
Then the next tab, that's tab 12, is the English language version of the explanatory memorandum. And probably we need to read the passage which starts on page 16.
What do you say is the status of the experiment?
Well, we accept that under certain circumstances, but refer to as different things. Parliamentary materials, which clearly would cover this, can be admissible to assist with interpretation. We think that I was going to come to this as a separate set of submissions, but Richard raises it now. The decision in Gowan Grant, probably good authority for that. That's at tab 18 in the authorities manual. Where in the judgment of paragraph 29, he says, a reference to parliamentary material has, of course, become commonplace since the previous rule that excluded this was relaxed by Taff and Hart. And the rather strict rules that were laid down in that case have become gradually more relaxed. It remains the case that this approach should be used only where the legislation is ambiguous, and then only with circumspection. When it is used, however, the purpose of the exercise is to determine Whether there is a difference between different stages of parliamentary material, however, I think the Welsh Ministers, at least, relied possibly on the case of the previous time at Westminster City Council International Asylum Support Service. And there, Lord Stay, paragraph 5, came on to talk about what he refers to as explanatory notes. And said the question is whether in aid of interpretation of the statute the court may take into account the explanatory notes, and also to what extent. The starting point is that language in all legal tests plays meaning for the circumstances in which it's used. It follows that the context must always be identified and considered before the process of construction or during it. It is therefore wrong to say the court may only resort to evidence in the contextual scene when an ambiguity has arisen. And of course, there are notes that will accompany piece of legislation when it is made. Notes indeed. What we are looking at the moment is the explanatory memorandum which accompanies the bill, as it says on its face. Indeed, for what it is worth, these do contain explanatory notes. And Appendix B, which one imagines that's an internal page 103, which we'll check when we look at the entire version of the legislation. It may well have been appended to the end. I'm not sure of the reasons. Whereas what we do submit is therefore that the explanatory memorandum, and indeed the white paper, and I suppose the debate in the plenary session of the National Assembly, would fall under grant exception, and would really only need to be looked at if there was ambiguity or absurdity on the face of the legislation.
Am I correct in saying your submission is there are two parts to this document? The first is the government's own understanding of what the legislation is, and we should be careful about that. And Annex B, the explanatory notes are akin to that which we have in Westminster, and that is
the expansion notes would, in my submission, have to ultimately gone through with the Act itself. I don't know whether these are the notes which were used, or indeed whether there were explanatory notes to this legislation.
which is this document, and we look at it, which it's in the document.
Your Lordships will find these explanatory notes here particularly unhelpful. If we turn to
Starting here, can I or can I not report to look at the explanatory memorandum, not the notes? Can I look at the parts before we get to Annex B?
our submission is that only if there is an ambiguity or first on the face of the legislation.
Only if ambiguity, can you look at the explanatory memorandum?
That will include the entirety of this document, including its Annex B.
Except there's an ambiguity in
Well, my Lord, our submissions are these. On the Welsh version of the text, absolutely not. It is crystal clear. In relation to the English version, we actually say that is very clear as well. I'm going to take your Lordship to what my learned friend says are the different possibilities of placing the word only. The problem with what he says is that sometimes it does make a difference, and sometimes it doesn't. And therefore, because of where the word only is
I don't
placed,
understand that. Sometimes,
well,
what is the submission you're making? Or are you commenting on this?
the submission I'm making, the English version 2, is clear enough that it bears the same meaning as the Welsh. To that extent, therefore, there is no need to look at the explanatory notes on the memorandum in order to determine what the purpose of the Act is. The passages, however, which may assist in the Affirmative Memorandum are those which start at 342 novels under the heading School Organisation. And it is quite clear in tab 12, the authorities bundle, it's in terms of page 16. I think it's page 236 on the authority. Thus, in paragraph 346, we see the description of the previous regime, reference to the School Standards and Framework Act 1998, and the second sentence reads, if any objections are received, the proposals must be determined by the Welsh Ministers. The Welsh Ministers may approve the proposals with or without modification or reject them. Then it refers to the Welsh Ministers and the Learning and Skills Act 2000 to bring forward its own proposals. And then at 348, it summarises the current process for making changes to school organisation. And the 1, 2, 3, 4, 5, 6 bullet point again is the reference to objections and the procedure that has to be followed. Over the page at 350, we learn that presently all proposals which receive objections must be determined by the Welsh Minister. On average, over the last 5 years, this has amounted to 17 proposals a year. Not that many. But in both 2009, 10, 11, the figure was 22. Then there's a suggestion that the school organisation process takes too long at 351. And at 353, the fact that it allows for a single objector without even a direct interest in the school cause a referral. And then there's reference to the fact that the closure of schools with few or no pupils is subject to the same process. Before coming to what the bill is intended to do, repeals the various elements of existing legislation on school organisation in Wales and replaces them with a single comprehensive legislative framework. And that is the first thing it does, put all disparate elements that were English and Welsh law into a single piece of Welsh legislation. And therefore, much of the existing legislation has been restated, albeit in a modified form. In our submission in relation to sixth form reorganisation, that is precisely what has happened. But the last sentence of paragraph 356, they will ensure that the vast majority of proposals are determined at the local level, and in many instances the process should be swifter. So it is clear from that the principal mischief that Welsh Ministers consider they need to deal with is this question of objections causing a referral automatically in all cases. Then we come to paragraph 357. And the second bullet point, and I can entirely accept why my learned friend relies on this. Instead of a situation where all proposals which receive objections are referred to Welsh Ministers, only those proposals which receive an objection from a local authority, or a school, a religious capital, a religious body, or which are connected solely with the removal of the establishment of sexual provision, will be referred to the Welsh Ministers. But my submission, this is why the judge said what he did, that solely here means just, only, beyond, take what to the Welsh version, i.e. it doesn't consider any of the matters that have given rise to difficulties in the past. And therefore the Davies said the word solely doesn't really add anything at all.
Could that paragraph apply
proposal
we did the proposal which is connected solely with the removal of Statutory sixth form provision at Pontypridd High School.
My submission is not intended to mean.
Judge couldn't apply to it, but it doesn't matter because it's not meant to apply to it. That's my submission.
My Lord, if the proposal is connected with the removal of a sixth form,
solely. That's why I was asking about this paragraph. This paragraph does. Well, there are two things. One, if it applies solely there, it doesn't apply to the proposals for the Pontypridd High School, and your submission is that it's not the end of the world because that's just describing one situation and other situations can be important. And I'm trying to work out which is your proposal.
My proposal, clearly, it solely means and does not involve, by virtue of the proposal, the reorganisation of any other sort of education. Then the paragraph clearly favours the application. But this is not the situation. And when one looks at this document in the whole, solely there does not, in our submission, bear that meaning. Because looked at as a whole, the legislation is attempting to provide a situation where it is proposals where objections do not necessarily.
So it's not an exhaustive.
But I'm saying that solely effective in any form.
So my understanding is 3.57 seems to be a significant note because it says specifically the bill introduces these the following significant changes in the way in which school organisation proposals are determined. And the first thing is introduces a statutory code model on best practice. It tells you the advantages of that. And then it says, and this is dealing with the substantive change, instead of a situation where, as you say, all proposals which receive any objections are referred to the ministers, only those proposals which receive an objection from the local authority, that's the first point, or those proposals which are connected solely with the removal or establishment of sixth form provision. So, I mean, it's pretty clear that it's telling you there are two changes here. And one is you get rid of the single objection carries directly, and the other is that only proposals that are solely to do with removal and establishment of sixth form provision will be referred. I mean, it's quite a gradual explanation of the change. And then it goes on to say what will happen. Proposals which receive more than one objection, which again supports your proposition that that was an important part of the legislation, and explains that, and then it explains about proposals which do not receive objections, and then fewer than 10 pupils on the rush. So those are the substantive changes the legislation is making to the current situation. So, I mean, I don't see how you could just say to my lord, you ignore the word solely.
Well, I recognise the problem that word solely poses. It is actually less of a hurdle in the which I will come to. It is significant in my submission that none of the further bullet points then describe what happened in this separate category of referrals. My submission is, despite what it says at the top in paragraph 3.57, here the current situation is effectively being, of the legislation is being kept the same, at least as regards the substance of the procedures was supposed to be changed.
Sorry, just say that again.
Because sixth form closures, the organisations, had always historically, since conclusion, been a matter for the Welsh Ministers, what I'm suggesting is here that in fact no change is being proposed, because they will still be a matter of referral to the Welsh Ministers.
Well, that's puzzling, isn't it?
I mean, the rationale, which was in that passage, paragraph explanation in the article, which the judge accepted, having been taken to a description of the funding arrangements in Wales for school relief, was that sixth forms, even if they are part of larger secondary schools, are the responsibility of the funding of the Welsh Ministers directly. Accepts that.
Yeah. The problem, once again, your problem here is not only with the word solely, it's also with the word only in this English version. Because it says, instead of a situation where everything goes to the Welsh Ministers, only two things go to the Welsh Ministers. One, when there's an objection from the local authority or the religious body, or ones which are connected solely with the movements of the Statutory Notice. And so it's not telling you that previously sixth form provision changes education options, because we know everything went to the Welsh Ministers. It's saying instead of a situation where everything went to the Welsh Ministers, we now have only two things that go to the Welsh Ministers: objections to local authorities and things solely to do with the establishment or removal of sixth form provision. I mean, it couldn't be clear.
We don't have a problem with the word only. That, of course, is the change the Lordship has just outlined. Now you have to be a specific category of objector to cause a referral. And the other instance in which there will be a referral is when there's the removal or establishment of sixth form provision.
Yeah. Solely.
Well,
Yeah, but it's a narrowing down. It narrows with only and it narrows with solely, and it's specific and it's narrowing.
I'll explain why I don't have a problem, my lady, with the first only. I accept solely is difficult, but this extent, we say, does contradict what the legislation is. What I've been attempting to do is to show that in the grand scheme of this part of the Act, it is clear that it was the removal of the objections basis that was the real problem, and that one should not attach, in what is after all only an expensive memorandum, too much significance to the use of the word solely, which, I mean, if it had read or which are simply connected with the removal or establishment of the sixth form provision. That is the meaning of the transmission that it attempts to convey.
But it does beg the question, it has no purpose, what's the point of putting it in?
Well, but this isn't legislation.
I know it's not legislation, Mr. Davies, but even so.
The Welsh version uses the phrase anemic.
Well, can we go to it?
Yes. Can we go through that slowly to make sure? Because,
Or should we have the translation? Should we have any interpretation on this?
well, I don't mind either way, but if I can just
Before you go into it, if you don't mind, Mr. Williams,
Yes.
which page is paragraph 3.57 in the Welsh?
It is in tab 13. It starts on internal page 19, and the bullet point is on
20. Okay.
361.
361. And that's the second bullet, which starts in hydrant.
Yes. Instead of.
Well, now I'm with you on the Welsh. Now, my lady asked whether we should have translation. So we'll use these headphones, whether they get us anywhere, we'll see.
Yes, I'm not sure that's going to assist, and it's certainly going to assist me, because I'm going to be able to hear what the translation
Shall I try and go through it and tell you where I put the pauses in case I've made a mistake?
Yeah, of course.
It's the last 4 lines after the words in Oh, well, nai gynygion,
Which line?
line 1, 2, 3, 4, 5, just after the words in parentheses. Nai gynygion, 2 words, or proposals. C, annoyed, an unig, which make only.
Well, annoyed isn't making, which are to do
with, yes.
Which are only to do with.
Which are only to do with, okay, only to do with. Dilai nesefadlu, proposal to make, declare or establish.
Abolish or establish.
Abolish or establish, yes. Darparia gwerthfed dosbarth, 6th form provision.
Yes.
Right. It's only to do with abolishing or establishing 6th form provision. And then, if we go to the top, after the first line and a half, after when we dog John Company, the Welsh Ministers, that's the bit that says instead of everything going to the when we dog John Company, it says her unig only gynigion proposals, which the authority or the religious objection, and then we get to the bit that we just looked at. So it's very similar, isn't it?
The only proposals which are referred to will be those proposals which.
And there are 2 types. That's my what Jeffrey Voss has said. The unig in line 2 with ministers in the English.
Yes.
And then the second unig is the solely in the English. Is that right?
Yes. But
can I say that on my right I can see the interpreters nodding as the translation is going on.
Diane.
which means
Well done to you. It's what everybody says in Welsh, Diane. Tap into the bonnet and say, well done. But I got it right though.
well, yes. The point I'm making is what that means is which are only to do with, which is not quite the same thing, which is saying which are to do with only this set of circumstances. So that they do not involve proposals to which there are objections, for instance, by a privileged objector. They are just proposals to do with abolishing or establishing 6th form provision. That is why I was trying to convey that meaning to the word solely. I appreciate that there's a struggle.
But what would only mean in that context?
In colloquial English, just. They are no more significant than. Which is why I use the word simply.
And first unig in line 2?
Well, there it's early nickname. So the better translation in my submission is the only proposal. Of course, enig is an adjective as well as an adjective.
And that means there are the only proposals are 2 sets.
Yes. And I have no problem at all, of course, with the accepted translation of only, the first, the only, in the bullet point in the English version.
What's the difference between the only and unig?
Well, and the third is the definite article. The only. And is a very difficult word to translate. It comes before adjectives and adverbs and verbs, and the verbs is always normally translated as being in Welsh. I am running, but it doesn't really have a translation at all. But it does denote here that this is being used adverbally, i.e. after the verb, which perhaps involved or are to do with unmade things.
Unmade is to do, isn't it?
Unmade is to do, and unmade are
is to do with.
Is to do with. Concern, I suppose.
Concerning, yes.
So that's right. Why is it not? Why is only to do with more reasonably the same concerns solely.
Well, in my submission, it does reflect an aspect of solely, but not the aspect that my learned friend would have.
Isn't it actually worse for you? I mean, only to do with it means not to do with anything else. Yes.
Well, yes, but it's not to do with anything else of the things that we've been talking about previously, notably objections from Category 1 objectors.
You might translate to do with as concern. Yes. It only concerns solely. If it only concerns, it concerns nothing else. That's my point.
Or it concerns these matters, but nothing else of the matters that we've been discussing before.
You would probably say anyway, we shouldn't be construing this document.
That would be my principal submission. I have probably spent not too much on this document. I promise to take you in great detail to the Welsh legislation, possibly tomorrow or even today. But the legislation itself deserves this attention. These documents, which I think it is common ground between the parties, which would only need to consider if you find a problem with the legislation itself. English or yes. It is really a secondary. So I suppose whilst I am here, just checking whether any other paragraphs are in the memorandum. Everything up to paragraph 3.61, take the English language version, which is the last paragraph dealing with school reorganisation before we get on to Welsh in education strategic plans, in my submission is consistent with what I've been submitting, but what this legislation is really intended to deal with.
It seems to me, speaking only for myself, is that you're obviously right that one of the purposes of the legislation is to do away with the one objector referral. But it doesn't seem to me at the moment that that is in any way to the exclusion of another objective, which is to do away with referrals, which were anything other than concerned only with sick forms. So, you could go to the right.
I mean, there is nothing in the Statutory Memorandum or the White Paper to suggest that referrals which involve six forms is an issue, is a problem. Obviously, I accept if the...
No, there isn't, but there is something, which is that referrals of a lot of schools is a problem. So what they're saying is they want to move from a situation where all the school proposals are referred to the Welsh Ministers to a situation where only a minority is.
Well, even on the respondent's interpretation, we are still talking about a small number.
Well, I know that, but it's not a minority. And you have to do two things to move from a situation where everything is referred to move to a situation where nothing or very little is referred. First, you have to get rid of the single objective counts rule. Once you've got rid of that, you then have to remove all the school five and sixth forms. Because the sixth forms are the only thing that the Welsh Government's interested in because it pays for them.
Yes, even under the old regime, reorganisation of the school which didn't involve sixth forms, so classically primary school, in which there were no objections, and withdrawn, would not have been referred. And they, of course, are the vast majority of far, far more primary schools in Wales than there are secondary schools, as elsewhere. So we're already talking about a relatively small portion of the possibility of all.
What is the proportion? 3 to 1?
I'll try and get the figures later. I suspect it's very much. We could take on the current draft as an example.
You can imagine the answer, you see, because small is in the eye of the beholder. The Welsh ministers have got lot of things to do. And they have just decided, as a matter of principle, without a kind of Welsh subsidiarity, non-sixth form things go to the local authority, sixth form things go to us for one analysis. And it isn't really enough to say, well, actually, it's not that bad if you stop and think about it. It's not that many. It doesn't matter. If their view is one is too many, surely that is a matter for the government or the Senate.
Well, yes, of course, we're arguing that between the parties not crossover. Because all non-sixth form proposals are not going to be referred. And on both our cases, sixth form colleges are going to be referred. It is secondary schools which include a sixth form. And the rationale for those being referred, because of the funding issue, is just as good as it is for a sixth form college. So, yes, the numbers in themselves are important, but it is significant in my submission that the potential problem that there would be a few referrals that the Welsh Government are going to get rid of is not referred to at all in these documents. The only problem is referred to, there are more than one, but principally the objective issue, and then of course the issue of small schools and schools with virtually no pupils.
Right. We've got the white paper, we've got the explanatory memorandum.
Yes, I suppose logically, my lord, we should look at the debate in the Assembly.
I think I've got the Welsh version.
Can I?
This is the plenary statement.
Yes, this is a transcript of the, as I understand, the index. So supplementary bundle. This is a part transcript of the Welsh Assembly plenary statement, session on the 24th of April 2012. I think, however,
Looking at the beginning, we see that we are now raised with being told whether expressions of the First Minister, business statement, statement of the Welsh Government's approach, etc.
I think you're maybe looking at a page that I don't have. I was going, just in order to identify, there were three passages that we set out in our original skeleton. Can I ask you all just to look at the core bundle? Tab 10, because they are set out verbatim.
And what tabs is it on? These are pages.
It's page 117.
It starts at page 117, and it's in fact page 132. Maybe I'm... Perhaps it is the first two pages in the bundle. But this, we set out the context in paragraph 49, on bottom of page 142. Plenary session held on the 24th of April. The then Minister for Education and Skills, Mr. Leighton Andrews AM, stated, in answer to a question from Angela Burns AM, and then that is what he said, and it's the sentence which starts, however, is underlined there for emphasis.
We said it's in English, so I can ignore the Welsh for this purpose, because that's somebody else's translation.
Yes, as I understand it, because you will see, for instance, over the page that Simon Thomas, I think that I can read, there was a I can remember, that it's reported in the left-hand column in the language of the question mark.
Would be translation of the right.
The right.
So I can actually focus on not struggling with the Welsh ones.
Yes, right. But looking at that quotation, the underlined part is not the entirety of the relevant part. So you have to read the whole passage. On school organisation, I'm delighted that she shares my view that one objector should not be able to trigger a reference. Good, your point. Yes, absolutely. As she will understand, I'm now telling you more, it says, we're trying to take Welsh Ministers out of the picture in respect of the bulk of school organisation proposals. There will now be local determination of them. However, I'm now telling you what's not included in that. The post-16 education, because there are issues regarding the relationship between sixth forms and other post-16, it's important that the Welsh Ministers retain the right to intervene. So, by providing statutory guidance on this in the way we're phrasing, it will be clearer. So it's a pretty clear statement, actually. Precisely what we saw in the explanatory memorandum.
Yes, it in my submission supports the respondent's interpretation entirely, because post-16 education must include post-16 education within an institution such as a secondary school, which includes the sixth form, and then it gives the precise reason for that, namely the relationship between sixth forms and other forms of post-16 education and the funding.
However, for post-16 education, even if it's in a school where there's also 11 to 16 education, it's going to be an intervention.
Yes, I mean the funding issue would be exactly the same, and then also there's nothing to indicate there that the Minister was trying to say to distinguish between these two situations.
It wouldn't it contradict what he said in the bulk of the school, or most schools have that stage? Is that right? That's what the Chancellor not doing.
Yeah.
It's supposed to do, so it couldn't be the bulk, could it?
But the bulk, the Welsh Ministers wished to remove themselves from the picture from the bulk. The bulk was school organisations in relation to primary schools, school organisations in relation to even schools up to under 16, I suppose.
So that's a fair 11. So you say, well, this is ambiguous, really, and it's only a statement in answer to your question, because the bulk is anyway primary schools, and therefore, if you took out all of secondary schools, you'd still have the bulk within the non-referred section. So this doesn't change anything.
It doesn't make that distinction, no.
So that's your point.
Again, it's entirely consistent with our interpretation.
Well, yes, it's possible.
Well, I make this submission. The Minister is not making this distinction.
Is this the only part of the...
No, there are two others.
Can we go and look at the others?
Yes. The next one is set out in paragraph 50. It is on page 6 of the bundle in the transcript. It's a short paragraph. I think we've set out the entirety of it. In respect of school organisation, he asked a specific question. So this is an answer to Mr. Simon Thomas in relation to sixth forms. Indeed, I will retain responsibility for determining proposals from override sixth forms. So there is a specific change in that. Sorry, there is no specific change in that. So the status quo was the situation is being retained.
You've got to, again, have a semiotic discussion, because you can either remove or add something is there. And it's not probably by taking away a whole school which has sixth form, or if you talk about in a closer way, removing sixth form, even if it's one bit of another school. You can't add something unless it's something there already.
Well, yes, the specific change is what were the powers, or what was the situation in relation to the Borough before this had been enforced, where all the sixth form reorganisation would have been done.
Just have to look at the question. Is the question at page 5?
It starts.
The recommendation to confirm what he's doing is restating his part of the context of sixth form restructuring. This is just not helpful. We don't really know what you're asking him to answer.
I think Mr. Thomas's question starts on page 2, Mr. Ellis Run.
Going back in the previous thing.
Yes. And then the last one is paragraph 51 of our skeleton, in answer to a question from Susie Davies, which is at the start of the answer is on page 9, but the quoted bit is the end of the paragraph on page 10. There is a difference, where the Minister is explaining the rationale for funding regime. There is a difference with post-section education. It is centrally funded. It is not funded through the revenue support grant. It is funded on a different basis. We make specific allocations. Because we had national funding and planning system in place until I suspended it. This was designed to ensure more equity between sixth form provision and further education provision, and served us well for several years, but this was probably unnecessary duplication of provision as we Council Wales. Again, clearly the distinction is how the funding is derived, not where the sixth form itself is found, or within a secondary school. Well, those are the three passages from the transcript of the previous session that we relied on below, and insofar as you were regards to this material, we say those are relevant considerations. I think that probably brings me back to the grounds of appeal. Took your lordships through the various provisions in chapters 2 and 3.
We've now got the complete statute.
Yes, I think it's possibly only section 1, which was all relevant. I don't actually have it in front of me. We're going to look at that overnight. Of course, the first ground of appeal is in relation to whether or not Section 50 provides an exhaustive definition. And this is based on the judge, paragraph 77 of his judgment. That's in the core bundle, tab 7, at page 64. Now, whilst we say that there's actually nothing wrong in the approach that the judge took, candidly except it was not part of our case at the first instance, because our submission was that on the facts of the case, proposals 2 and 3 fell squarely within the ambit of Section 50, Section 2A, at least as was made clear by the Welsh version. So therefore, there was no need for us to argue that there might be other situations in which sixth form education might be affected outside of that subsection, albeit that the judge is surely right when he says that this would have been, the case would have been made clear had the word only introduced into the line proposals affect sixth form education, if, which is what he held at paragraph 77.
Really, I mean, it's you don't need it because it's saying proposals affect sixth form education, which is the requirement of subsection 1, if X or Y. You can imagine other legislation saying something complicated. For example, carpets are covered by the Act if they are light in colour. Subsection 2, carpets are light in colour if they are white or cream. No, if they're yellow, they're not light.
Well, I mean, the matter is certainly put in doubt by the suggestion of the judges. They said that would be one way of rendering it clear that this is still my act.
Because it says carpets are light in colour. Proposals affect sixth form education if this condition. You don't need only. That works.
The only difference in the Welsh context here is that the word if doesn't appear in the main context. It tracks down into the subject. Now, whether or not that makes a difference, I'm not sure. But the reason that this came about, this is not the judge going off on a product of his own, because I think he cites it. When it looks at the Council's own skeleton argument, which is at tab 11 in full bundle, and it looks at paragraph 23.
Sorry, I didn't catch the reference.
Tab 11, paragraph 23 of the defendant of the general skeleton argument, page 166 in the full bundle. In subsection 2, purports to cite the Act, or at least to summarise the provisions of the Act, by saying section 50, subsection 2 of the 213 Act proposals affect sixth form education if and only if they are either proposals to establish or discontinue. So the idea that this needed to be an exhaustive definition, and that would be denoted by the words only, was a hair the defendant started to rub. And as a matter of statutory interpretation, of course, it was right. The judge said, in order for them to win this, it did, it's sort of the way that Respondent put his case, but it did need to be exhaustive, and the proposal in question did need to find itself outside of the exhaustive definition. As a matter of logic, that must be right. But the really important point is surely what the judge says in the very next paragraph, because this has absolutely no bearing on his finding in relation to the interpretation that we put forward, and a little bit of a red herring in our solution, whether or not the judge was technically right about needing the word only or similar expression. So perhaps
Switch it down too.
yes. We say that on a proper reading, section 52A covers proposals to discontinue a school, in this case such as Pontypridd or Hawthorne High School, a school which provides education in the form of sixth form education, that sixth form education, of course, is that which is suitable only for the requirements of pupils aged 16 to 19, above compulsory school age. It's not a requirement to say the schools have only provided, which should be a sixth form college, provided it does provide education, whether on its own or in conjunction with education for children of compulsory school age. The point about there isn't such I don't think this takes the matter much further, but of course there is specific to sixth form. It's Key Stage 5. In Wales it involves studying to AS levels and then A levels in year 13. It is possible for people in sixth form to receive education which is not only suitable for the sixth form education. There can be people who are resitting their GCSEs.
But what they're getting in is what they got in 50.
Yes.
So they're having to do it again because they screwed up the first time.
Yes. I confess I'm not entirely sure I was responsible for funding of those people. But it really doesn't affect the point that they're making.
What they're getting is still the education they got in the form. They're getting it the second time. They may have been here. But it's not something that's different from the below. It's just that they're getting it later than others.
Yes.
Not trying to stop the construction at all, finish.
Well, no, but I don't think it can. And we say that that interpretation is reached on an analysis of both language versions, provisions of section 15, and also by a contrast with language used in other subsections in this part. And of course, as we've already seen, so far as the same is necessary by consideration of some of the preparatory material that was available. My Lord, it seems to be common ground as to how one should treat the Welsh version of the legislation, but perhaps I can just take the Lordship to the relevant provisions.
Well, can we do what we did, just I'd like to go through it slowly to make sure that I understood it. Would you mind bearing with me on that?
Yes, of course.
Part 5 is 50 to A, and the English Graduate proposal.
I simply, before we got there, you're not sure that there is ahead, please. I was going to take Lordships to the provisions, which indicate that this is why this process is necessary. One cannot just ignore the provision version or assume that it says the same thing as the and to an extent, the kind of was guilty of that. But if your Lordship wants to go straight to
Just take over a minute. The opening words, my pleasure, and the right to that is proposal, qualification, and then they are selling, they are, and this is where you get what they are, and Ganagion, yes, proposal, which is being running to set up or close a school. Yes. And that's what it's all about. And would you accept that the words that come after are describing what the school is that falls within the description or qualification of us from?
The first subclause, after starting with the word "seed," which of course is a contraction of "seed." Yes,
and see then is which are, what I would say, or is see then not?
Well, here it would have to be which is, because the verb is going with the school, not with the proposal.
Which is then, rather than which is the Ariada.
C,
Yes. C is a contraction of C, Y, W, C, N, which is.
If it assists,
Ariada, which is education, provision of education, or education provision, I suppose, not it. Well,
that is a verb. So
provide education. But seeing that
can I just make a suggestion? The judge wanted to do this exactly exercise. In in order to assist, he asked whether it was possible to provide.
No, I don't want to go conversation. I want to go through it with you to get mine.
Well, of course. Yeah. But what it did do, with square brackets, it broke up various parts of the Welsh.
I'm not interested in translation. I'd like to understand if I can understand.
I'm sorry.
So we give it gynegyol, proposal. The gynegyol is the funding everybody ysgol, the set up of those schools, and then we've got a description, C, which is the harrier, which provides education. It's not just provide education, it has to be C other anger anyone, and that means which is appropriate to requirement. And it's the requirement of persona person, C draft order as of a word of, or above compulsory school age. Now if you stop then, if you never got to the that would describe your case. It would describe which we type, because that is good enough law, which does provide at that stage, which is suitable to people above school age, you wouldn't need any, would you?
You're right that my learned friend needs ENIC, and he needs it to apply to a particular part of the sentence, whereas in theory at least do without but it's there. It's our duty.
What's the function if the respondent doesn't need an ENIC? Because if you never got an ENIC, it would cover your case. If you are a school, you do provide education at higher level, which is suitable to people about age 16, others are having young people like you, small children, that sort of level. It also has other things as well. So that would cover the form or the form in an identification school, wouldn't it?
Yes, because that Harry would not then be qualified.
So what is your position? What function does an ENIC perform in that sub-clause?
It qualifies because there's another sub-clause. See now, Harry out. But then see now that's having any fun. Well, and all the way to the comma. There's another sub-clause. Because it is the education which is suitable. So an ENIC must qualify that.
Must qualify the requirement.
Yeah. Yeah.
But it's only that which is suitable when you are thinking about it. It's only that which is only suitable.
Think logic to the various versions and then translate that with placing it for the only.
Then you show that company, education people drop out from the but it also retain education down below how does that work with an English? It's trying to define it, the education, whether it's the adaptive, or whether it's a requirement, or whether it's a person. In each case, the only is trying to qualify what the school provided.
Well, the answer is no, because an ENIC is not in the same clause as the others provide education.
So if I got there, all I know is the quality of school, the quality provided education, I still don't know quite what. So when I go on to the next page, I'm going to talk to people who over. So by the time I got there, I know what we're talking about. So,
this is called education. This is AS level 5 A. Yeah, that's according to strong.
so I moved to school, and then I tried to static, which is suitable only or which is I believe without
it's trying to describe, and we'll move to that the suitability of the education which is being provided. It is not trying to say, and this is why I want to take it forward to the grammar in these and he cannot it can be done. Yeah, yes, it has to apply because that's happening in the borough. It's a lot. Yeah, it has to apply.
But what it does, that's why it started to go beyond and everything else is trying to explain to you what is going on. Of course, so this is the matter where the complication is happening. It is clear that what you're saying is distinct. It provides something only. Then it's limited. The school provides something else.
But when you watch it says only provide, qualifications going with that value. Oh, right.
Okay. But the suitable, which provide education suitable to 6-year-olds only.
That English doesn't make an awful lot of sense. Depends what one means. But an English answer possibly the French meaning alone.
It's either qualifying as or it's qualifying as requirement. But in each case, it's limiting the future of the requirement, something relating to the self-responsibility.
But the message is qualifying the suitability. Now that's the meaning. Which means qualifying the education, so the education is suitable. But education which is suitable for children over compulsory schooling is sixth form education.
This is where it's providing education for and very well, most countries doesn't know any meaning.
If the proposal of the organisation is that we know that it starts to indicate that in the third.
How should we
it would be possible to use this window possibly prevent you doing what really done in 1967 work. But in trying to give meaning to the word and meaning must have the suitability of the matter. It does, and then I'm going to laugh at this.
I should be work. I should have if you take out take it easy. So if the proposal to discontinue maybe over 16. So if the proposal to discontinue school providing education over 16 only, I will not read the thing to you. The otherwise they'd be.
Well, the way to answer that is to offer a translation back from this into English. The scene is equivalent to the relative pronoun provides a subject. Now, ideally, there should be a comma, as there should in my understanding of English comma. But the mere absence of the comma doesn't rob the scene of its meaning and purpose.
What I'm suggesting is there isn't a comma because it's an entirely conditional clause. Those aspects of education, as you pointed out, if it's a conditional clause, if this whole clause is satisfied, namely, if the person consistently is school providing education to the age of 16. What I don't understand is how you get to it being impossible, as you say, to qualify anything education suitable to the needs of the age of 16.
Yes, I think.
Look, it is now important.
Yeah.
I know you wanted to do this in the morning, but I suspect you'll have more to say about it, and you may benefit from having to think about it. I mean, anyway, for my part, I think I'm now reasonably familiar with the Welsh words.
When you're thinking about the Chancellor's question, a related question, why have an innate clause? Because if the only purpose is make it clear that something that has, that a school that has provision for over 16, whether it's got any other provision for, why you need to say only at all? Because by saying it's got to be education other than getting your authority or once you say that, what purpose in the sentence can mean it have at all? If it's meant to include for education, why have an in it? Because once you've said university age, that's the end of the definition. If that's what you want to do.
Would it be possible to render it that way, my lord? Which, you must have said which only has, again, as attaching the sense of an unit to the verb.
Yeah, I'm trying not to ask you a different question. I don't know what to call it. I'm not interested in answer the question, you answer that one. I'm asking a different question. So don't worry about what the word attached to it. Worry about a different question. Your case is, if a school provides education suitable to people over the possible school age, it's called, and this is the school, or be it, provides education to people below school age. And if that's, you define it before you get to it. So what purpose in life does an innate purpose in that subject? You see my question is related to different questions in Chancellor.
And you also want to answer that tomorrow?
Yes. I'll answer my last question first.
Yes, sir.
And then my question after respect.
Yes. Good. Are we on time reasonably?
No, I think so.
Yes. Okay. We'll meet again at 10:30.
All right.
Your call will be disconnected.